Thank you so much for being here. My name is Liz McGill. I'm the Dean of the Law School, and I'm just delighted to welcome all of you to this terrific event on building China's new IP case system, a discussion with Chinese judges and legal and big data experts. This seminar is one we're really proud of because it's another in a series of great successes of a project of the law school directed by Dr. Meg Ash, the China Guiding Cases Project, which Stanford founded in 2011. Within a very short time, this project has developed a unique online knowledge base that has benefited readers all over the world. The project has been presented in many influential forums, including the World Bank and legal exchange conferences hosted by the United States and the Chinese governments. Tonight, I want to thank the many Chinese authorities and distinguished speakers here for helping the China Guiding Cases Project take another step to promote the rule of law developments that are taking place in China. Speaking about rule of law developments, I would like to emphasize that the law school is broadly committed to a diversified research platform for the world's outstanding scholars and experts to help promote the rule of law both inside and outside of the United States. Our course offerings and our research programs take a close look at developments taking place in the United States and in Asia, Africa, and the Middle East. Our unique programs, like the Afghanistan Legal Education Project, the Iraq Legal Education Initiative, the Rwanda Legal Development Project, and the Cambodia Law and Policy Initiative, focus on long-term needs of these countries by helping them to build sustainable legal regimes. In addition to the China Guiding Cases Project, Stanford Law School is really proud to be home to the China Law and Policy Association, a China-related student group. Beyond the China course offerings offered at China students at the Stanford Law School, students also have the opportunity to study abroad through established relationships with our partner, Peking University Law School. And for the larger Stanford community, we enjoy the Stanford Center at Peking University, which is a headquarters for our faculty and students engaged in research and teaching and training and many different outreach activities in China. I know we'll be able to do more after tonight's seminar to support China's continued development of its legal system. In addition to the efforts contributed by the Guiding Cases Project, our alumni and our students connected with China have helped and will also continue to be able to help us achieve more in the future. Nearly 3% of Stanford Law School alumni are based in Asia. In September, I had the pleasure of making my third visit to China. This was a third visit to Asia. I went to Hong Kong and Shanghai on this latest trip, and I was incredibly impressed with the incredible work being done by our alumni and friends of the law school there. Right now, 45% of our international students at the law school today are from the Asia region, and 10% of our international students are either from Hong Kong or mainland China. All of these students are the future leaders who will empower the law school further to pursue these meaningful endeavors related to China over the coming years. Judge Liu, Judge Fletcher, Judge Liu, Judge Fletcher, Mr. Liu, and Professor Lee, Dr. Getchlik has told me how much you have done to help her team, and I'm incredibly grateful, and I know she is. On behalf of the law school, I thank you for your kind support of all of our efforts, and particularly in helping us pull together this evening's event. We look forward to working closely with you in the future to sustain our successes and reach even further to support the development of the rule of law worldwide while deepening our important relationship with China. Professor Mark Lemley, who directs Stanford Law School's program in Law, Science, and Technology, is also here, and he wanted to say a few words of welcome.
Thank you, Dean McGill. I just wanted to briefly add my welcome on behalf of the program in Law, Science, and Technology. We are obviously very excited about the possibilities for cooperation in general with China legal system, but I wanted to identify some specific ones with respect to intellectual property. We have a long history of doing work with respect to intellectual property in China. We have twice brought justices from the Chinese Supreme People's Court here to Stanford for an extended program of mutual education around intellectual property issues. I hope that we will do that again. And we are very excited to have Judge Liu here from the new Beijing IP Court. The new Beijing IP Court is a big deal, not only a big deal in China, it's a big deal in the United States. It is in the United States press in the last 24 hours because it has high-profile cases involving Apple and Qualcomm. And I think the idea of a specialty court focused on intellectual property is going to be extraordinarily important and influential. So I hope you have a good evening discussing these issues. If you don't get enough, I want to invite you all tomorrow to our conference held here on patent law and global perspective, which will also feature Judge Liu, among others, in a panel discussing United States patent law issues and issues of patent law interest across borders, including everything from international tax to trans-border infringement. So with that, let me turn it over to Professor Getschlich and wish you all a good evening.
Thank you very much. Thank you very much, Dean McGill and Professor Lemley, for coming here to welcome our guests and distinguished speakers. My name is Meg Ash. I'm the founder and director of the China Guiding Cases Project. Unfortunately, tonight, Judge Jiang cannot be here, but he will be here tomorrow and will be able to participate in other activities that we have organized for him. Fortunately, other Chinese speakers are here, but they are probably exhausted because they just arrived a few hours ago. Similarly, Judge Fletcher probably is very tired after a long day at work. So in any case, despite the fatigue, I believe that tonight's exciting discussions will keep everyone stay awake. Well, before I start, because this actually seminar is about China's new IP case system. So this system is based on, well, it's built on top of China's case guidance system. I believe that it will be helpful if I provide an overview of this background, so then you have a better understanding about today's discussion. Before I start, I would like to let you know that all of the presentations, including mine, are being videotaped, okay, and will be videotaped. And then at the end of this seminar, we will post all the videos on our website for educational purposes. So if you're very, very keen on asking anything, any questions, please hold until Q&A, all right? Thanks very much. And now, talking about the Chinese new IP case system, the establishment of this new the case guidance system was first mentioned in the second five-year court reform plan released by the Supreme People's Court. In this plan, it talks about the importance of using guiding cases for unifying the standards for the application of law and guiding the adjudication work of lower-level courts. But how to do that? So then that's why the Supreme People's Court mentioned that they will formulate regulatory documents on this system. Indeed, after this, then in late 2010, the first set of rules on guiding cases was released by the Supreme People's Court. In that document, judges were told when they handle some cases similar to guiding cases, they should refer to guiding cases. On this, I have to emphasize that only should refer to, not must refer to, largely because, well, cases in China, this civil law-based country, they are not regarded as source of Chinese law. So at most, they can only say should refer to guiding cases. However, even though strictly speaking, judges are not obligated to refer to guiding cases, but they are strongly encouraged by the Supreme People's Court to do so. And this strong encouragement was emphasized in another set of rules released in 2015. And in that rules, actually, the Supreme Court provided more details. And then they said that, well, when judges refer to guiding cases, make sure that you actually refer to this particular section of the guiding cases. It's called main points of the adjudication of guiding case. Now, in your folder, we prepare a lot of documents, and we provide two samples for your reference. Guiding case number 78 and guiding case 84. These are translations prepared by CGCP, reflecting a lot of hard work. And then you can see that, in fact, guiding cases are summaries of full text judgments. They're just summaries. But each guiding case covers the facts of the case, results, and reasons provided by the judges in the judgment. But then there's one particular section, it's called main points of the adjudication. Usually, well, there are 1 or 2 paragraphs outlining the legal principles applied by the judges in the judgment. As a result, now it's very clear that you're supposed to refer to these main points of the adjudication in subsequent cases. Right now, we have altogether, well, after so many years, after about 7 years of development, altogether we have 87 guiding cases released by the Supreme People's Court. And then, well, then how many subsequent cases actually explicitly referring to guiding cases? Altogether, by the end of 2015, our team, CGCP team, identified 181 subsequent cases. This number rose to 519 by the end of 2016. Well, by the end of this year, we expect to see a lot more. Well, of these 87 guiding cases, there are different types. And then 54 of these guiding cases are civil cases covering different areas like tort, contract, commonly intellectual property. If you take a look into intellectual property, actually altogether we have 20 guiding cases about intellectual property or unfair competition. But you probably notice, wait, but there are not many subsequent cases referencing these guiding cases. How do you explain that? It's because 10 of these IP-related guiding cases were not released until a few months ago. So it will take a while before we can see similar subsequent cases. Well, you probably noticed that then, well, there are 3 tort-related guiding cases, and there are altogether 187 subsequent cases. What happened? Guiding case 24 is about, well, a victim of car accident trying to claim compensation from insurance company. Well, as you can imagine, car accidents happen quite often in different parts of the country. So that's why it's not a surprise to see more subsequent cases. For more information about these guiding cases, a complete list of guiding cases and, well, some data about subsequent cases, you may refer to this, well, document where you can find bios of, well, our speakers today, and also you can find these numbers for more reference. Then, well, recent developments, okay, in China show that the term guiding case, the term case guidance actually has a broader meaning beyond guiding cases. Why do I say that? Let me give you an example by using Belt and Road Initiative to show you. As you probably know, Belt and Road Initiative was mentioned by Chinese President Xi Jinping in 2013. And then this is an initiative to encourage Chinese companies to go overseas and invest there, okay? So this is a very, well, ambitious initiative trying to cover many countries. In fact, the initiative has been expanding. Look at the camel. This is a logo created by us. So look at the camel. It covers Asia, Europe, Africa, and now the camel actually has arrived in Latin America. If you actually, well, in 2015, the Supreme People's Court issued a very important document to talk about the role of people's courts in helping the development of the Belt and Road Initiative. And then it says that, well, in order to do that, well, we have to strengthen case guidance. But by what? Not just by releasing guiding cases, but by releasing so-called typical cases, 典型案例, so as to help effectively prevent legal risks encountered by Chinese companies when they invest overseas. So then, as a result, now we have altogether 18 typical cases related to Belt and Road. And this is a table to show you the first 8 typical cases. And you can see that each of these cases actually have a party from a Belt and Road country. What is remarkable about these cases is that, well, very often judges, as illustrated by the text in red, judges in China, they might not be able to find any actual relevant Chinese legal principles. Then they will actually refer to the international legal principles. And then here, for example, well, in typical case numbers 7, this is a case worth noting. At that time when the judgment was rendered, there were no rules in China about demand guarantees. The court in that case referred to the International Chamber of Commerce rules on demand guarantees. Afterwards, more similar cases happened, and then the Supreme Court accumulated enough experience to finally feel comfortable and release a set of rules on demand guarantees in December 2016. And that's the reason why, to some extent, these cases help propel judicial reforms. Then, well, as you can see, it looks like that cases in China are becoming more and more important. And that's the reason why the China Guiding Cases Project has launched a new publication called China Cases Insights. Altogether, we have 2 issues published. The first issue was actually, written by Judge Walker, commenting on Guiding Case number 78. And the second issue was written by me, together with a CGCP member, commenting on, Guiding Case number 17 about food and Chinese medicine. It was just a fun project for me, Chinese medicine. I couldn't resist. And then in your folder, you probably also see a publication, actually also written by me, published by Hoover Institution. In this particular article, I tried to step back and think out of the box to discuss how guiding case is actually relevant to the development of US-China cyber relations. So I hope you enjoy that. And then, finally, this is the last part of my presentation. Then, can you tell me more about how guiding cases have been used by legal actors like the attorneys and judges? At the end of 2015, we have identified 181 subsequent cases. Altogether, in 134 of these cases, we noticed that at least one party or their attorney mentioned a guiding case in their arguments. And then most of these cases, unfortunately, 96 of these cases, the deciding courts did not actually make any response at all. Even the attorneys themselves actually talked about guiding cases. But on the other hand, 47 of these 181 subsequent cases, the party actually, or attorneys, they didn't even mention any guiding case, but the judges actually took the initiative to cite a guiding case. So that's very encouraging. But this one slide can show that, in fact, there's room for improvement. As a result, in fact, the Supreme Court mentioned in the 4th 5-year court reform plan covering 2014 to next year, saying that we need to improve the case guidance system. And then they also emphasized the importance of published cases to help promoting understanding of law. And then they also emphasized the need to improve database of cases. Yesterday, President Xi Jinping delivered his speech at the 9th National Congress of the Communist Party in China. He emphasized 2 goals to be achieved. He said that we need to deepen the reform of the judicial system, and we strive to let the people feel fairness and justice in every judicial case. And I highlight every judicial case. As a result, you can see that the focus on cases actually is strong. But how to do that? Case guidance system can be so broad, covering different types of cases, and that's the reason why we're here tonight. In 2015, Beijing IP Court took a bold step to have an experiment. They actually were chosen by the Supreme Court to establish a case guidance system particularly focused on intellectual property issues. And Judge Jiang prepared a very nice presentation about the big data, how to use big data to support the construction of this new case system. Then later, Judge Liu will talk about how the system actually has been applied. It's been going on for some time, and he has some interesting data to illustrate the development. And we are very lucky to have Mr. John Liu, the Chief Technology Officer of this big data company, Grissom Holding Inc. And then he's going to show us a video as well, to illustrate how to use the database. And then Professor Leon Li, he actually will, as a scholar and also a practitioner in China, he will explain why now, why we have this case system in a statute-based country, and how we can sustain this effort. Then finally, we are very fortunate to have Judge Fletcher to share with us American perspective, trying to help us connect the dots by talking about why a public database of judicial decisions is essential to system of commercial law. So this is actually, I hope, this helps you understand the context, and then we can have a more fruitful discussion during the Q&A part. Because Judge Jiang is not here, so, and because I actually work very closely with him to prepare his slides. So I would like, because I don't want to miss the chance, he prepared excellent presentation. So I would like to share his presentation with you, so then you understand this, topic that he wants to cover. Thank you, Shohan. Okay, so basically this presentation covers three aspects, okay? Why IP courts were chosen to do this first, and then how they actually establish a base for IP case guidance, and then, the development of the big data platform to support the system. The IP courts were chosen to initiate, to take this to be the first, to be the pioneer, to carry out this initiative, primarily because of the following four reasons. While IP education tends to have an international focus, and because this area, IP, develops so rapidly, so a lot of times the legislation looks dated very quickly, and with omissions, ambiguities, and an incomplete coverage. In addition to that, the Supreme Court has chosen Beijing IP Court as the court to carry out tentative judicial reform measures. And also, IP education itself is very specialized, and because of that, it's very conducive to the development to the accumulation of related judicial experience to help them think about how to further improve the case guidance system. Then, how to establish the base, okay, for this purpose. And then, Supreme Court in 2015, established this IP case guidance and research Beijing base inside the Beijing IP Court. The purpose is to strengthen standardized judicial interpretations and case guidance, and also to unify standards for application of law. And then there are four goals for this particular base to achieve. The first one is actually this base will be used, maybe I should say, is being used as a national research center for IP case guidance. Second, this base is going to help, identify IP-related guiding cases, because there's so many. And then this base also serves another purpose, to serve as an information center for IP cases. And the fourth is that this is a national comprehensive service center for IP case guidance. As a result, you can see a lot of hopes are invested in this base, and then they actually plan it very nicely. Well, it consists of three stages. Stage 1, 2015, they built the framework. And now, right now, they are actually developing the database. So that's the reason why we are particularly honored to have a chance to see how the database functions. Okay, and then next year, beginning from next year, they will try to promote this database nationwide in China, and also find some ways to connect with international databases. During the reception, Mr. Zhang already had a chance to get to know Professor Mark Lamley, and I believe the first step of connection was made. Then the third aspect of this presentation covers how the big data platform was built. And then altogether, there are three subsystems on this platform. The first one, of course, you have to find the cases actually to be included in the database. So that's why the system for reviewing cases. Then once they were chosen, then they will be included on the website in the database, being made available to the public. Then the third system is a system for applying cases, because application actually, you need the parties, legal actors, know how to use them. As a result, you need some knowledge base to support the understanding. So that's why there will be an entire IP knowledge base available to facilitate application. Well, with respect to the review of cases, you can see this is actually the flow, okay? First of all, you have some candidate cases, okay, recommended manually by human beings and by machine, automatic identification. And then after that, these candidate cases are reviewed by experts. And then as a result, there will be some editorial input. And finally, going through some final review inside the court, and released to the public through the website. And then those cases will be available on the platform for citation and application. And I just talked about application of cases actually involve a lot of information. So altogether, there are 8 aspects. First, they have one part about basic cases, and then another part more significant cases. And then this one is called main points of significant cases. And on this, I would like to ask Judge Liu later to comment whether these main points of significant cases are very similar to, whether they're similar to the so-called main points of adjudication that we find in each guiding case. And then they also have a part about legal rules and other area covering IP information, patent tests, and IP knowledge related materials. So overall, these are the features of the big data platform. Well, the first 3 actually identify how this platform serves the needs of different parties. For example, the first one, judges' needs related to adjudication of cases. The second one is the need of the Supreme Court to supervise and guide education of IP cases across the country. And the third one is actually the public needs. Well, but this actually create an open platform, open to everyone, so then the societies can actually address the needs related to litigation. Ultimately, this platform is all about the collection of judicial data with particular focus on cases so as to ensure the organic development of judicial practice. There are a lot of aspirations for the developments of this initiative. Ultimately, these are the goals they want to achieve. While judges can actually make sure that similar cases are adjudicated similarly. While judges' discretionary power will be limited, restricted, and then they will be able to distinguish cases based on legal reasoning. They will be able to explain why cases are adjudicated differently. And then because now judges with this database, they have more information, more guidance, then when they deal with new types of cases, they feel more confident. And then the chance for them to make mistakes will be reduced. And then finally, after, especially with big data analysis and analytics, then they can accumulate judicial experience to provide reference for policy making. Thank you very much. I'm done. Too much talking from me. Okay. So, thank you for your patience. Well, on this, I would like to invite Judge Liu to talk about how exactly the system has been implemented in Beijing IP Court.
I'm very excited. Distinguished guests, ladies and gentlemen, good evening. It's my great honor to be at Stanford Law School and to have this opportunity to speak with all of you. I'm going to introduce you the current situation of the implementation of the Supreme People's Court, that is SPC, and the exploration and the practices of the Beijing Intellectual Property Court, hearing after that the BIPC, in applying and developing the IP case guidance system in trials. Part 1, China's guiding cases system and its current status. As we all know, China is a statute law country. Thus, prior effective judgments or rulings is not a formal source of law. However, with the rapid development of society and the economy, and the increasing litigation scales in China, the contradiction between the litigation demands and the supply of judicial resources gradually show up, and the issue of treating like cases unlike had become prominent in judicial practice. As such, the SPC makes it clear to establish a case guidance system in the second 5-year reform outline, as is mentioned by May. I'm not talking this too much. However, actually, there are some problems in practice showed by judicial practice since the inception of the case guidance system with Chinese characteristics. The number of cases in which judges have actually invoked the prior guiding system is very limited, resulting in a poor operation effect, which is mainly shown in the following aspects. Firstly, unwilling to use. Given that the guiding cases are not source of law, judges who are subject to the rules and the mindset of statute laws are not willing to invoke the guiding cases because they think they may burden their case handling. Secondly, unable to use. Invoking identification and analogy of guiding cases require certain judicial skills and experience, but most judges lack the habit and methodology to use guiding cases. Okay. Thirdly, insufficient for use. Due to the very small number, the guiding cases published by the SPC are far from satisfying the needs of the judicial practice. Part 2, I will introduce the main measures taken in exploring and practice the IP case guidance system. On April 24th, 2015, the SPC established the Intellectual Property Case Guidance and Research.
Otherwise, the audience cannot.
Sorry. Okay. On April 24th, 2015, SPC has established the Intellectual Property Case Guidance and Research Beijing-based hearing after a case base in BIPC, which should the main task to explore the establishment of IP case guidance system with Chinese characteristics. Compared to the existing system, BIPC's exploration has the following features. Firstly, specify the nature and effect of IP case guidance. Beijing IP Court endeavors to establish a principle. Subsequent cases should be adjudicated in accordance with the effective judgments and rulings of prior similar cases. At the current stage, judges of the Beijing IP Court are required to abide by the court's effective judgments and rulings that are applicable to the pending cases as well as those of upper-level courts. If other courts at the same level have prior similar cases, the judgments or rulings of this case should be referenced by the judges adjudicating the pending cases. Secondly, to motivate the social force to comment on IP prior cases, under the support of the Information Technology Department of the SPC and the law database companies, the case base extensively collects excellent judicial judgments home and abroad and invite Peking University, Tsinghua University, and other first-class schools jointly carry out cooperative study and formulate the work rules and method for selecting IP guiding cases. A consulting committee consisting of more than 200 voluntary law experts established for this purpose. At present, more than 500 IP typical cases with guidance significance has been selected and published. Thirdly, build extensive consensus and encourage joint participation by IP law community. The operation of the IP case guidance system requires the joint participation of the whole IP law community, including judges, lawyers, patent attorneys, and other IP practitioners, and must rely on plenty of judicial practice to verify. BIPC has held over 30 seminars of different size to jointly carry out theoretical study and practice discussion with the experts in relevant fields, and has reached extensive consensus among legal community.
Meanwhile, BIPC encouraged parties to submit prior effective judgments or rulings, also allow lawyers to invoke prior effective judgments or rulings, and request judges to first examine and then respond to and explain them. Also, BIPC makes special procedural guide for following and reference IP guiding cases and formulate the trial rules for harmonization of litigation, hearing, and judgment. Part 3, I will introduce the preliminary success achieved in exploring and practicing the IP case guidance system. Since the start of system exploration to the end of 2016, the court has effectively implemented treating like cases alike through invoking prior effective judgments or rulings in the trial. Here is some. The prior effective judgments or rulings, we use them in 763 cases. Prior effective judgments or rulings in 653 cases are submitted by parties to case, and the prior effective judgments or rulings in 106 cases are voluntarily invoked by judges. From the adjudication results of these 763 cases, judgments are made following the prior effective judgments in more than 200 cases. Judgments are made not following the prior effective judgments in over 80 cases due to difference in affected. And in the rest cases, prior effective judgments or rulings were completely irrelevant or not submitted via appropriate procedures. The positive effect in exploring the practice of IP case guidance system has gradually appeared. Firstly, judges' mindset began to change. They take quality before efficiency and become more positive in pursuing the professional and meticulous judicial spread of craftsmen, and welcome parties to case and lawyers to submit their prior effective judgments or rulings and deliver high-level accusing and defense opinions. Secondly, judicial capacity of judges have remarkably improved. Accurate application of identification technology to define similar cases has effectively ensured treating like cases alike. Thirdly, the transparency of judicial activities has greatly improved. As judicial credibility grows and the leading role of judicial protection of IP emerges, China has gradually become preferable choice for overseas and domestic IP litigations, which has enhanced the international image of the IP judicial protection in China. Fourthly, lawyers, high-tech enterprises, cultural enterprises, and other innovation entities, as well as experts, scholars, and other social forces had paid high attention to and provide great support to the system exploration, and they eagerly expect to participate in this exploration and share the system bonus. Okay, thank you.
Thank you very much, Judge Liu. Then next speaker is Mr. John Liu. John is going to, I have to use this? Okay. John is going to explain, now we have been waiting for a long time how this database actually really functions. So he's going to actually show some slides to explain the concept, and then he's going to have a video to demonstrate how actually the database works. If you actually, you can actually ignore my other materials, but not this, okay? This one is the one you want. Probably that's the reason why we have so many people tonight. You can have the information here to have free trial access to the database. Thank you, John.
Thank you, May. Well, good evening, everyone. It's my great pleasure and honor to be here tonight. And I would like to thank Stanford Law School for this opportunity to share GridSum's effort in the IP-focused case guidance system. We function as the technology enabler and provider in this endeavor. Before I start, I would like to introduce a few of my colleagues who are also present tonight. They're sitting in the audience. Scarlett, who is our VP of Business Development, and Wang Meng and Shui. Shui's right, she's taking picture. The reason I wanted to introduce them is to emphasize that this system is not possible without their efforts. And the reason is that these few, they're GridSum employees. GridSum is a software company, but these two people, Wang Meng and Shui, they were legal professionals, legal practitioners. They have years of experiences in the Chinese court system as judges before they joined GridSum in our endeavor to build the smart court system. Oops, what did I do? The smart court is a vision from the Chief Justice and the President of the Supreme People's Court, Zhou Qiang. He wanted to build the smart court system to promote the interconnectivity and data and information sharing in order to increase the trial quality and benefit the public. And also with the goal to build an open, transparent, dynamic, and people-oriented judicial mechanism. As you can see from the timeline, that the progress, the effort in building the smart court has been quite remarkable. And also the initial results have been very impressive, as you have already seen from the previous presentations. From February 2016, when the initial kickoff of the Smart Court initiative, to it took only less than 2 years to see the initial results, which is quite remarkable. The construction, the building and development of the Smart Court system has actually two most important overarching goals. The first one is to automate the trial process. And the second, more importantly, is to optimize the decision-making process. And this is also what GridSum has been doing in all other areas where we take the big data that's available in that particular space and try to do our best to optimize, to help the industry optimize their existing business process as well as decision-making process. But this effort, this particular effort to build the smart court system is a tremendous effort, and it's a tremendous collaborative effort by many organizations in addition to GridSum. We have partnered with the Supreme People's Court Press, which developed the Faxin, the knowledge base, which is the foundation of the smart court system. We also partner extensively, which I would say jointly developed the IP-focused case guidance system with the Beijing IP Court, the research base based in Beijing. And also, the initial results have been tried and it was a lot of feedback from the Chinese court system at all levels. We also partner with Peking University, who's provided many expertise in the legal system, in the knowledge system. So the smart core solution consists of 7 pillars, I would say. At the very foundation, the base of the solution is the Faxin legal database. As you can see, the rest of the 6 systems, 6 pillars, are all intended to either automate the process, part of the trial process, or to optimize, to improve the decision-making process. We'll talk more about the IP case guidance system later on in the video demo. We developed a speech recognition and transcription system to facilitate, to help the automated record keeping in the trial process. And this has already been deployed in many courts in China. We are also developing a document generation system in order to automatically generate some of the legal documents in the trial process. The detection of similar case system is also quite interesting. When a judge comes to a decision, he or she can use this system to gauge where his judgment or his decision lies among all the similar cases. The intelligent question and answer system is also a tool to allow legal professionals as well as the ordinary people to know more about the legal system or issues related to his or her concern, as we also show an example in a demo that follows. The remote trial system is another exciting effort that we're jointly developing with the Beijing IP Court. This is intended to also expedite the trial process. In many cases, the bottlenecks are to get all the parties together in the courtroom. With the remote trial system, that doesn't have to be the case anymore. In some of the cases, the trial process can actually happen with parties occurring in different locations remotely, online. So that can actually solve a lot of the process problem. So we believe that this will greatly improve the efficiency of the trial process. Now, the underlying technology to support the smart system, the smart court system, is really quite essential and exciting. We use the natural language processing technology. As you know, Chinese language is a little more complex than the English language because we need to, in order to understand the Chinese language, we need to break apart the words. The Chinese language are character-based. Characters together form words, phrases, and then sentences, paragraphs, and the entire document. The English language comes nicely with words broken out already. So Grissom has been working on the Chinese language processing for many years, and we also partner with some of the leading research institutions in China to refine our natural language processing engine. We use machine learning. We use the knowledge graph to turn a document, a plain text, into knowledge. And by building a graph, we can then build connections among the key concepts and discover relationship among the concepts. On the right-hand side of this slide, you see the 2 key data mining technique that we apply in the system. The multidimensional drill down allows you to ask many questions, and the correlation analysis allows you to build correlations, find out relationship in the key entities and concepts. So this is just a summary of all the key technologies and how they are applied across the 7 subsystems of the smart court platform. Next, I will use a video to demonstrate the IP case guidance system.
Offers the big data and AI-facilitated capability to identify relevant cases and push them to judges to give them guidance based on Grisom's AI engine feature called Smart Push. Judges can input the partial or full text of an effective judgment or ruling, and then the platform will push to judges highly relevant previous cases for reference and guidance. Now, I am entering a judgment of a trademark infringement and unfair competition case. Without adding any additional keywords and with just one click, the platform automatically analyzes and pushes key information from an abstract of relevant cases that match with the judgment. As you can see on the screen, the abstract of the case that I enter and the results of the relevant cases pushed to me are highly matched with the core essence and key dynamics of the case from legal standpoints. This will help the judge to instantaneously see similar previous cases and compare key case dynamic and outcomes. The Smart Push function does not require key in the full text of the judgment. Powered by the leading Chinese NLP engine, it also supports naturally formed search queries, making it useful for users who are not familiar with legal jargons. Let me show you an example. This is a case where the plaintiff finds that an official WeChat account plagiarized the author's article. But the author has no idea of the key regulations governing this issue or the criteria and outcomes from the previous judgments in the similar cases across China. Let us examine how this platform will significantly help the author. Here we again enter the Smart Push functionality. We don't need to use accurate legal jargon. The intelligence of the system allows us to use ordinary expressions. For example, I just need to input an official WeChat account published my article without my consent. Then the platform will instantaneously push relevant and significant case for my reference. And through the abstracts and the content pushed to users, users can learn about the relevant legal status, similar cases, different judgment and rulings, judges' perspectives about copyright protection on WeChat public platform, and statistical analysis of similar case outcomes. Even an official WeChat account, especially one that is used for commercial purposes, reposts someone's article without permission or plagiarize content, then this is an act of copyright infringement. We can see here that there are substantial cases on copyright protection of original content on WeChat official account. The platform also provides interactive data analysis based on big data analytics and AI interpretation for judgments and other key data. There is no limit on the number of dimensions or variables for cross-correlation analysis or the order in which queries are conducted. If a user wants to know the criteria for determining damages for copyright infringement of an WeChat official account, the user can input official account and article as keywords, and then input compensation as a keyword at the space trial judgment as follows. Click to choose court option in drill-down dimension to filter different judgments and obtain the following results. Take Hangzhou, for example. where an official WeChat account plagiarized from an article. As we can see, Hangzhou West Lake District People's Court awarded 2,600 to 3,500 yuan in damages. Hangzhou Binjiang District People's Court awarded 2,000 to 3,000 yuan in damages. In contrast, the People's Court of Yueshou District of Guangzhou awarded 550 to 650 yuan in damages. The reasons behind these differences may be based on the quality of the article or the variance in the IP protection enforcement across the local jurisdictions. Now we see that for similar cases, different regions may apply different criteria when deciding damages. This platform will allow users to clearly understand the criteria and choose a court which may protect intellectual property better than the others to initiate legal proceedings.
Well, thank you very much.
John, this is an excellent demonstration. Next, because we don't want to keep everyone waiting, I would like to introduce Professor Liang Li. The whole event can happen because of him. He put all the Chinese parties and me together. And then he's very good, well, he's a dear friend. He's very good at holding back information, not telling me all the hurdles we had to go through before this can happen. Had I known that, I might be hesitant. But anyway, he's a terrific cheerleader and partner.
Thank you, May. Thank you so much. As feedback to May's praise, first, I needed to express my deepest appreciation for May's extraordinary effort. Without her extraordinary effort, we can't come to present our opinion and exchange our thoughts. Thank you, May. Thank you so much. And I'll take the opportunity to talk about a very interesting thing for Chinese for this world. Why China, as a statutory based country, has interest to develop case system. Would like this system would be like, and how what process we will go through to achieve satisfying result. This is the story I want to deliver tonight. Here. You know, case system is a strange thing for China. First, I needed to introduce the background of Chinese legal sources. You may notice that we have various legal sources according current regulations, but you may tell among the 8 items without a case that the judges can follow during their jurisdictions. That's why I needed to introduce a case system is very important. Further, I will explore the reasons why we need why we need a case system now. A case system, the biggest problem is similar case adjudicated differently. There are 3 types of similar case adjudicated differently. The first is a similar case adjudicated different by courts located in different provinces. You may know that China is is geographically vast, and we have more than 30 provinces. And the West and the East maintain a great difference. These reasons may result in this phenomena. And the type 2 is a similar case adjudicated different by different courts located in the same province. Even the same province, different cities, I needed to first to introduce a background. We have a hierarchy, Supreme Court, High Court of each province, and we have mediatory court for each city, and even a different city, we often share the different understanding between their judges. Maybe because the local culture and something else, and we have the type 3. The phenomenon is a similar case adjudicated differently by judges of the same court. This is another big issue. Even the same court cannot deliver uniform judgment. Actually, it's not a normal phenomenon. Even the process of judgment is a serious process. We cannot tolerate such a phenomenon. So we realize this point. We need to know. We need to do something to change this phenomenon. With the summarization, we can list 4 reasons for the problem. It is just briefly described. I think we can explore more reasons, but we talk about these 4 points first. The first, the uncertainty. Chinese, the statute has a very typical trait. It is often changed from time to time. It's because a statute, when it's generated, it often lack of prediction for future things. So I think to some extent, this uncertainty means unstable. So that's the reason why statutes cannot solve everything in our society. And the other trait is inflexibility. Statutes, provide limited coverage, and they cannot. I think the legislator, the lawmaker, cannot predict everything and solve everything in future. That's why I list inflexibility. And the third trait is discrepancy. Judges have differences in understanding of status. This conflict we need to solve because the justice means a uniform application of law. The fourth point I need to address is the judge's performance limited by inadequate competence and time. In China's the Chinese judges, to be a Chinese judge is not like the road how to grow to be a United States judge. It's totally different. Even a young law school graduate can become a judge not many years later after his or her graduation. And this phenomenon means that the lack of experience, lack of expertise, and all of these factors negatively affect the judge's performance. I can further explore this point. Inadequate competence. I presented 2 graphs. You can See, the first is the Chinese judge is structure. You may know that our judge is very, very young, and because of many reasons. One reason is our open policy is still experience a couple of 40 years, just 40 years. And with the same step of our justice conjunction, we need still a lot of work to do. And this is one reason. And the other reason is that the conjunction of our judges team is different from the Western developed countries. And the second graph is Chinese judge education background. You may know that actually the PhD at law, the judges number who obtained a PhD is a handful. In the vast group of judges, not like American law schools education model. We usually after obtaining a bachelor degree, we need to further have a master degree and a PhD degree. This means we need a long time training for our law school students. Not like American judges. Many, I think most of American judges with GID background. So PhD at 10% means we still need a lot of training for our current judges. I need to make a quick introduction. And this is another graph I present. This is the first is the first tense case adjudicated by Chinese judges. During the flight to here, I had a conversation with Judge Liu. He told me at hand he has almost 500 pending cases to adjudicated.
More than 500.
More than 500. This means even without adding new case to him, he needed 2 years to finalize all of the adjudication of the cases. So you may know the workload a Chinese judge have. They have no time to do sophisticated and serious research. Aside of the 4 reasons, I want to list 2 needs because for a case system. One is, China is facing a turning point. This means this is a result of a rapid economic development, and the many social conflict, which I think President Xi Jinping just delivered his speech yesterday. And we also has another need for case system because of our open policy. In recent years, Chinese enterprises and the Chinese government is endeavors to endeavor to develop more to overseas investment. This means we needed to provide our Chinese enterprises for more protection from the countries they invested, and as a reciprocity, by making sure that legal rights and interests of foreign investors in China, we need to provide the same protection. As for the reasons we described, we mentioned above, statutory cannot provide a full protection. So a case system is rendered and it is discussed for this need. One minute.
You can say
Okay. Okay. The third part, how to proceed with the case law system. For the purpose of promoting uniform application of law, implementing the system of guidance issued by SPC. Actually, many courts in different provinces experiencing the testing of a case system. They try to require their judges to reference and even abide by the effective adjudication. Beijing IP Court's IP case system is a good trial in this direction. I just mentioned another reform our Supreme Court conducted. This is a judge's personnel reform. With this reform, we can ensure one point. I don't want to say this point can solve everything, but I think to some extent it will change the situation. And personnel reform means we have a fixed number of judges team, and without retirement, without quitting, we cannot add the judges number. This means our judge team can be with mature age and to be a skilled expertise to ensure the quality of adjudicating process. As a system, establishing a case system to promote uniform application, increase judicial transparency and strengthen legal protection involves efforts contributed by various parties. I think that the roles judges, practitioners, academic institutions can play in the process. Our center, the CUFE, the Central University of Finance and Economics, Law School's Research Center, we has a very close connection with Supreme Court, with the help of Supreme Court and Stanford Law School, CGCP's project. We established this center in the beginning of this year. And we mission ourselves to uphold a series of seminars to promote the case system and provide a consultation for private sectors and government agencies. For example, many private sectors, enterprises in private sectors, they have a huge need to solve the development problem that they cannot find answers in statute. So they would like to seek resolutions from case system. We can further explore this point in Q&A if you have interest in this question. Thank you.
Thank you, Leon. Thank you very much, Leon. Although we are behind schedule, but we certainly have time for Judge Fletcher. Judge Fletcher, thanks very much for waiting.
Thank you very much. Thank you, May. I'm honored to be here. Thank you for organizing this. I'm pleased to be here with these judges, professors on this important point. It is absolutely critical to any successful system of commercial law that there be knowledge about what the law is, both in terms of what the underlying statutes are, and even in a civil system, what the cases are that have been decided under that system. It's one of the staples of comparative law to look at how the same problem is solved in different legal systems, both at the same time, that is to say, in the same time period, but also, although this is not ordinarily the staple of comparative law, in times past. And I want to give you 3 short perspectives that show you how these problems of uniformity of commercial law and publicizing of the cases and the statutes of commercial law have been handled in 3 different periods. First, I'll start with the early American period. We're accustomed, of course, now to having Westlaw, F3rd, FSUPs, more cases than we know what to do with, but that was not always the case. At the beginning of the American Republic, we had essentially nothing. A practicing lawyer in 1800 would likely have a copy of Blackstone, and that was it for commercial law. Now that poses enormous problems because what you need in commercial law is a known, predictable, stable system, because any commercial enterprise investing goods, time, money needs to know what the law is that will be applied to that, because you don't want to invest in conditions of uncertainty. Further, you want a uniform system so you don't have to deal with the law of New York, which is different from the law of South Carolina, which is different from the law of Massachusetts. That was handled in the beginning by looking at Blackstone, and then fairly early on by a number of foresighted judges working very hard to get case reports. So at the very beginning in New York, for example, the great lawyer, Chancellor Kent, said, in despair, we have no law and no one knows what it is. It's kind of a lovely non sequitur. The only case reports at the beginning that were widely available were the reports of the United States Supreme Court. And the United States Supreme Court in those days was a commercial court. It was not a constitutional court in the way that we think of it today. And the lawyers up and down the East Coast, the trading states, looked desperately to the United States Supreme Court for cases simply so they would know what the law was. New York starts fairly early on, Massachusetts fairly early on, Pennsylvania early on. Some of the southern states are much later. We don't get case reports out of South Carolina until the 1830s. We don't get them out of Mississippi until much later than that. But it was all a system that was growing. And it had 2 basic purposes. One was to make the American law within the United States, one so that American lawyers could understand in advising their clients what would happen if you enter into this kind of a contract and is then enforced in South Carolina. The second point, and I think this is probably equally important for purposes of China looking at how we solved our problems, we were a country emerging and trying to take our place in the trading nations of the Western world. And we wanted very much to have a law that the trading nations of the Western world, mostly in Europe, could look to our country and understand what we were doing and have a law that was more or less uniform with theirs. So that's our early American experience. I could go on for a much longer period. In my ill-spent youth, I read every reported American case from until 1845. So I've read them all, and it was not, well, I read fast. Okay, second, I want to speak about civil law experience with cases. China, of course, is a civil law system, but it's going to be a civil law adapted to China. It won't be identical to the civil law systems we see in Europe. But I would like to point out and take as my example the civil law system in France, where I've taught for many years. It's governed by statute. It's governed by the Napoleonic Code. Nonetheless, the case law of the French courts is an important part of their law. It's always by reference to the underlying statutory structure. But if you want to understand how the statutes work, you read the decisions of, for example, the Cour de Cassation, one of the appellate courts in France. Now, the decisions in the French courts are very short. They're not long, discursive, with extraordinary factual detail such as we have, but it's a case-based system that, I don't know, I want to say it this way. In some ways, the common law English-based system and the civil law systems have converged. There's a famous book by Guido Calabresi, The Law in the Age of Statutes. We are an age of statutes. We are no longer a common law system in the old sense of the judges making the law. The judges apply the statutes. So we look actually much more like the civil law system than we did in the 1800s. And the civil law systems have converged towards us. So while they've primarily emphasized the statutes, they also have case law as an important part of the tools of a practicing lawyer. And then finally, one of the pieces that struck me as I learned about the case law the database system that the Chinese are developing, which looks fascinating, is the judges select the cases that they will put into the database. And one might think, well, wait a minute, does that mean that there's going to be a kind of secret law because they choose the cases that they publicize? And I think immediately of the American system. Now, American lawyers may not focus on this, but we do the same thing. I can't tell you how many cases my court decides in a given year. It's thousands, and I'm just talking about the Ninth Circuit. And we publish very few of them. That is to say, we choose the cases that we put into, now we'll call it the case reporters, you'll call it the database, but the judges choose the cases that you are going to read. The other cases will give a written decision, and it'll be 2 pages long, and we forbid the lawyers to rely on them. We say, you can cite that case to us, it's a public record, but don't waste your time reading it because I'm not going to read it. And the reason we do it this way is to save everyone time and to make the system efficient. It's an impossible system if the lawyers were required to read every case that's ever been decided that's relevant to the point, because you'd spend a week reading to get a single point to get through the single cases. So just in case you were somehow worried that it's a bad system because the judges don't tell you all the cases they use, that they've selected the guiding cases, it's inescapable, and it's an entirely workable system. Finally, I'll simply close by saying I was startled by how young the judges are in China.
Sorry.
I became a judge when I was 49 years old. I'm now 72. My mother was a judge ahead of me, and she was a full-time judge working at age 89. So you have a long way to go if you want judges who are of suitable age and discretion for making these important decisions. Thank you.